And now we are inviting another speaker, and it will be another representative from Defense for Children International Italy. And Gabriella actively contributed to the development of the organization along the years and has huge experience in the direct management and supervision of several initiatives and activities for the promotion and the safeguard of children's rights in Italy and in Europe. So now we are moving to Italy and giving the floor to Gabriella.
Hello, thank you very much. Good afternoon. I try to share my screen, if I may.
Yes, please.
Can I see?
Not yet.
No, not yet. Okay. No. Okay, maybe now. I cannot do that.
Thomas, can you help us?
That is the issue, Gabriella. If you click the share screen,
yeah, I cannot see the presentation. I don't know why.
Do you have more windows opened? May you have to scroll down.
Yeah. I know. No, but it's not the first time. But in this case, I cannot see the presentation.
Can you share your screen? Or if you click the share screen button,
strange.
You can see. Let me share in this case the presentation for you.
Okay.
Can we make 5 minutes?
Yeah.
So we clear the issue?
Well, maybe if there is some, you have my presentation, so maybe if you can, I don't know why. It is the first time I see this. Okay. So, yes, good afternoon. Sorry for this problem. There are all the time problems with the screen but I'm very happy to be here and in this seminar, which is give us some perspective on the implementation of Directive 800 2016, and in particular on the issue of individual assessment. I will talk about our project CREW, which is implementing an analysis and also a study regarding the implementation of Directive in Italy. But at the moment we are in the very initial phase of the project because of the COVID situation. We have postponed the activity, and so we just started in October 19, and we are now in the research phase. So I don't have data to share with you, but I would like to start telling you our activity, now to give you a framework, because if you go down in the presentation, the first slide is indicating the activities of DCIs, just some pills of what we do in this domain in juvenile justice, because it's, as you may know, DCI is the juvenile justice is one of the key priority of our movement, and as DCI led the NGO panel to support the implementation of the UN Global Study on the situation of children deprived of liberty, and we participated in 2019 to the launch of the global study, and we presented our movie. This movie is Voices from the Inside, a movie that shows the reality and the perspective of adolescents into Italian detention centers. child participation is a cross-cutting issue for DCI, as June was saying before, and I have to say that in any action we aim at collecting and bringing out the voice, the perspective, the ideas of children and youth in order to inform our actions that concern them. For instance, we are now implementing a European project together with the University of Leiden as well, and the Defense for Children in Belgium, Young in Prison, called Youth Lab, where youth that were involved in criminal proceedings are participating with us in the training session with professionals as young trainers. And the idea is to contribute to build together a more child-friendly system. And then we have conducted consultation on the role of youth lawyers in criminal proceedings in order to solicit a reflection on the right to defense. We are also working on the other side of the medal, the protection of children who are victims of crime, saying the other side of the medal, because in many cases we can see a circularity between children who commit crime and children who are victims of crime. And now with the CREW project, the idea is to work on directive in practice, try to understand to which extent the directive is implemented in Italy, which are the gaps, and which are the possible actions that we can promote, we can suggest. And one of these objectives is to propose an individual assessment tool. So among that. And I would like saying, if you go into the second slide, I would like to start saying that the criminal proceeding in Italy is regulated by a presidential law 448. This is the other slide. This law contains some provisions on the trial involving juvenile offenders. And this law, which go back to 1988, is inspired by some enshrined some fundamental principles that are comes from the International Convention. The system aims to be child-friendly. The juvenile justice system in Italy aims to be child-friendly. The idea has been to adapt the ordinary trial so to safeguard the personality of the child who is still growing and is not in full maturity, as June very clearly explained before. I think that there is another slide. Can you go in the other slide? The second. So yeah, because what I wanted to mention is very, very general line and pills on the juvenile justice system in Italy. And these are four relevant elements that compose the juvenile justice system in Italy. These are four principles. One is the principle of suitability, so that measures are suitable to the personality and educational needs of the child. So the judge has to understand the context and the whole situation of the child, in addition to verifying the offense. Only in this way, the scope of the juvenile justice system can be reached. That is the educational and the social reintegration. And here there will be a lot to say about the individual assessment because and the child participation, because the juvenile trial in Italy is based on child participation. The child has to participate in order to give, to allow the professional to have a clear idea of his personality, of his responsibility, of his context. Another important principle is the minimum harm. In order to avoid the contact of the child with the criminal system compromises his child development, his personality, his image that he has or she has of herself or himself, with the consequent risk of social exclusion. So The system wants to avoid the potential traumatic experience that could represent a trial. And in fact, the Institute of Messa alla Prova, which is a sort of probation, has the scope to avoid the child to enter in the criminal proceeding. And at the same time undertake some restorative path. Another principle is the destigmatization. It aimed at protecting the individual and social identity of the child from processes of devaluation. Another is the principle of residual detention, is aiming to avoid the detention, which should be the last residual measure to be applied to children in the juvenile justice, and it is in Italy, in fact, because the number of juvenile in detention center is very small. So these are just some pills of the principle that are enshrined in our national legislation as far as the juvenile justice is concerned. And we can say that our system is in line with international and regional standards on juvenile justice, on the directive. And in fact, the Directive 800/2016 contains many elements of the Italian juvenile justice system. So you can change the slide, because now there is a question. So why we decided to proceed to submit such a project to the European Commission? Because we have seen that our system is really advanced and very much in line with these standards. So the idea of this project came out as a result of some activities that we did in the past. In particular, in 2019, in the framework of another European project, it was called My Lawyers, My Rights, with Defense for Children in Belgium. And together with the Department of Juvenile and Community Justice of the Ministry of Justice, which is also a precious partner of the CRU project, we carried out a detailed analysis of Directive 800/2016 in practice in the Italian situation, in view of the transposition due in 2019. So an interagency working group of experts composed by juvenile justice officials, magistrates, prosecutors, academia, lawyers was established. And together with these actors, some relevant gaps between theory and practice were identified. We analyzed the directive article by article, and at the end, we decided the Department of Juvenile Justice and Community Justice submitted to the Legislative Office some recommendation before the transposition of the directive. And then what we did, we decided to propose this project in order to provide a complete analysis of this, the directive in practice, because the reality showed some weaknesses. If you go in another slide, this was what I said. The other one, I reported here some voices collected by youth. You can go, because there are some sentences that that we collected in our activities. Federico, which is 20 years old, said, you should remember that behind a child who commits a crime, there is always a request for help, that there is always the possibility of making him change with the right approach, and that mistreating him and making him feel alone is not the key to opening shell and make him talk, but the best way to make it even thicker. So one of these young we are working with told us, because he had experience in the criminal proceeding. There is another one, if you go ahead. Sometimes the process of acknowledging your own mistakes is affected by the system blaming mechanism, which affect your own personality. This is another boy we are working with. And there is another one. This is an experience from a Roma girl, and that she said, when we arrived at the police station, they took me to a room. One of them grabbed me by the hair and slammed my head against the wall. He slapped my face without stopping insulting me. I was 16-year-old. These are experiences that we are collecting, and we would like to make a collection of, because we think that as you can see, that there are some moments, there are some elements that are still very critical, and the encountering with law enforcement is one of them, as was said before. We can go ahead. This is another girl that they told us lawyers should tell the truth, not fool us. This was about research about lawyers, youth lawyers. And then finally, okay, if you want to see the movie that I was mentioning before, I put the link in at the end of the presentation. There is a song composed by youth in juvenile justice in a juvenile detention center in Bari and Turin. One of the songs is called Forgotten. And there is this sentence in the "We are boys with bombed dreams, closed in a cage, forgotten by the state." So a very strong feeling from this boy. But to go quickly to the CREW objective. So the main objective is to contribute to achieve that all children involved in criminal proceedings as accused or suspect person have access to a child-friendly juvenile justice system that consider their individual needs and condition, so to determine tailored measure and aimed at the positive and harmonic personal development within society. So a very challenging and complex objective. The specific objectives are three. One, to contribute to harmonize the juvenile justice practices in 29 Italian judicial districts. The second is to systematize individual assessments through the development of a national methodology, and to build capacity and raise awareness of professional involved in individual assessment. So these three are the specific objectives. As I said, our project started in October 2019 because it was postponed because of the COVID emergency. And we are now, if you go ahead, these are the phases of our project that will last 24 months. So we are in the first step. The first step is the national harmonization process, which is a more research process. The second step is the systematization of individual assessment. This is the building up and proposing some tools, some practical tools regarding the individual assessment. And the third step is a capacity building and awareness raising activity. So we are now in the first step, as I said, and an interagency table, the interagency table that we established in 2019 has been re-established at by the Department of Juvenile Justice, the Juvenile Justice Department, which is the partner of the CREW project. And what we did was, in these past months, we elaborated a very complex questionnaire based on the directive that we are now starting to submit to juvenile justice professionals to collect their perspective on the practical implementation of the directive. So it contains really the idea is to collect information and data, on practical data on all the articles of the directive. We have met twice with this interagency group, and we are now starting the dissemination of the questionnaire. what we are starting also are some consultation with youth, because this is part of our activity, research activities. When we do research activities with professionals, we also want to hear what the children and youth want to say to us. I wanted to say just a few words on this interagency group. It is composed by around 20 people. And I said it was they are magistrates, prosecutors, juvenile prosecutors, social worker, juvenile justice official. And they responded with great enthusiasm to this invitation, of build together this first tools, no, to collect this data in all the territory in Italy, in all the 29 districts. The fact is that we all know that we have a great legislation, so we have a great legislative corpus, and I think that this enthusiasm is given by the fact that we all are proud of this this corpus, and we don't want to lose it. And in fact, as I said before, this presidential decree is dating back 1988. It was issued 1 year before the convention, and it really has inside the many principles of the convention. First of all, the fact of child participation. We go back to child participation one more time. I am concluding with this drawing. The last slide is a drawing that was done by a group of adolescents explaining what is the juvenile justice, what they want to be. This juvenile justice system is like a puzzle where all the pieces are fundamental. So the young person, but also the judge, the social workers, the lawyer, the educator, the police officer as well. So each part of it is fundamental and have to go in the same direction in order not to lose this culture, which is at the basis of this legislation, this precious legislation. I think that I finished. I put in the last slide the link to the documentary if you want to see it, and you can find also some other resources on our website. Thank you very much for your attention. I know that after this long day it's not easy to follow a presentation, so thank you very much, and thank you for inviting me to this event.
Thank you, Gabriella, for making the voices of young people sound. It's very...
Yeah, this was my intention.
So now we can move on all together to final remarks session, concluding remarks, and if you have any questions to Gabriella, you also can ask now in the box of questions and answers, or just can panelists also ask. So now I am giving the floor to our colleagues from Croatia, from Zagreb University, and Jolanta will help to moderate the discussion.
Okay. I just wanted to say, first of all, I would like to say thank you for our Zagreb University, our partners from the EA Child Project that accepted our invitation to make a concluding remarks. And I wanted to thank you on behalf of our whole team to Avril Calder, which is the former president of the International Association for Youth and Family Justices and Magistrates. So Avril, thank you for your input into this project. Thank you very much. Anya, I will just give you the floor for the concluding remarks.
Okay, thank you, Jolanta, and thank you all the presenters. Stephanie, June, and Gabriella really had inspiring presentations. So just in short, to conclude, and I will also have some questions, I guess Neven also. So we began with legal framework, and we concluded that it is really important. So also European Union documents, international, also UN documents and so on, and their quality implementation in national legal documents. However, how the individual assessment is conducted and used in practice is even more important, I think, and that many presenters try to point it out. So the main question actually is the quality of individual assessment. One of my questions in that sense would be to all of the presenters, do they in their countries maybe have some kind of quality standards for individual assessments? And maybe do they evaluate the work of professionals who work on individual assessments regarding to some specific indicators or something like that? Gabriella says no.
No, as far as I know,
Okay.
because I'm not in the system, so I'm
researching.
I don't think that there is a standard, and also that there are some indicators for self-assessment. That was something that came out some years ago from the professional working in the juvenile justice system, and we did, I cannot show it to you now, but we did a sort of tool for self-assessment based on the convention and on the legislation. So we provided this professional working in specifically in detention center, in juvenile detention center. But as far as I know, we don't have an official, and we are aiming at providing it, because in the CREW project, unfortunately, I don't have the results now, but we have the possibility to work in this direction, having the Department of Juvenile Justice of the Ministry of Justice as partner in the project.
Okay.
Gabriella is raising her hand.
Yes, I just wanted to add in answer to Anya's question that the youth offending teams, which serve every local municipality, have a hierarchy, of course, of social workers who work there, and there are always senior people. And before a report can leave the desk of the officer who wrote it, it must be presented to a senior manager in the team, and they will check it out and make sure that it is fit for purpose, which is a job worth doing, I think.
Okay.
Yes.
Maybe in Netherlands or Belgium?
In the Netherlands, the same actually applies as what Avril just mentioned, that there are always checks within the organization by senior people who manage a unit, or and that our report is never written by one person alone in that sense, but has always had some oversight by another person who checks it. And also I think they have these multidisciplinary meetings within the Child Protection Board, where the social workers can also consult with a psychologist and discuss what would be good to advise in that case. Maybe June, you know also more about that.
Yeah, and the same is also in the with youth probation. There's also a psychologist who looks at the results of the lay or another assessment. But I think the question was also if there has been in the Netherlands a broad research on the lay, and I know there has been a research, you know better, Stephanie, probably, but there has been a research, but that's more like how can we try to shorten it, make it briefer, but not like do we do it in a proper professional way. Of course, that would be a very interesting research, but of course in Europe we like to do the individual assessment not also like we do it now with delay, but make it in a broader approach, individual assessment, also looking more not only to the recidivism risk, but also to the care for the youngster, etc. So perhaps if it would be a next step if we have changed the individual assessment to make also then the broader research. I don't know.
Yeah, okay, thank you. I was also thinking about all of the things you've mentioned, all of three of you, but also about the national level and the, let's say, national level of standards of good quality for the assessment. So, you know, so every institution can check the checklist and say, okay, we should improve this and not this. Okay, thank you. And I have another question regarding participation of juveniles. So besides informing the child and using child-friendly language and so on, I would like to hear, what do you think? How to increase the level of participation, especially when you do detection and the different type of assessment, like comprehensive assessment? Do you maybe know, or you can tell something more about some methods and techniques professionals or assessors use to increase the level of participation of a child or of a young person? I mean, I agree with you that participation gives more motivation for intervention, but it goes both ways around. So if somebody is in, I don't know, for example, doesn't want to cooperate and so on, it's very hard to go on the higher levels of participation. So I would say that participation is in a way a method in intervention, a content of intervention, but also goal of intervention, but also of the assessment. So maybe if you can comment on that.
What I would think is that what I said before, it's very important that the one who talks to the youngster has kind of a relationship with him or her, but that's not always easy, of course. But sometimes it's also good to tell the youngster that he can bring well, not a friend perhaps, but more like a social supporter, an informal supporter, which can help also that by explaining what you can do for yourself, by thinking about what is my welfare and can I contribute to my own welfare. That is, I always think that explaining is part of the psychological relation you can have with the youngster. And explaining takes time, but I think it's worthwhile doing that. I don't know if that's an answer on the question, but that would be my first idea.
Yeah, I agree with you that giving information and explaining is like a first step. You cannot move to higher levels of participation if you don't do that. Maybe to reflect more on how do we create more opportunities for youngsters to participate, except explaining and bringing social support. I don't know if you have any experience or examples from your own practice.
Well, it depends.
Maybe, yeah.
Also,
Okay.
in which chain partner is trying to have a relationship with the youngster, because if you are the first in the chain, then it's of course difficult. But like if you're working at the youth probation officer, it's much more, not easy, I will say, but it's because then you can go with the youngster to a school or whatever, so you get more of a relationship. But that's of course in a further step in the chain, so a bit in a way easier. So I think it's more difficult for the police and the protection board of welfare agency to work with the youngsters in that respect. But still, I think explaining, because it's youngsters between their 12th and 18th, and if they have enough sense to understand things, they often understand that it's their own welfare to participate. So it's because they make also like a balance. And so I think that would be really helpful. Stephanie, you think so too?
Yes, I actually wanted to say that I agree with that, with both points, that for participation to take place, it is easier when there's more sort of a yeah, a long-lasting relationship between the social worker or other person who makes this report and the young person. So that is not a one-time opportunity for the young person to say what his or her opinion is, but that they have more of a back and forth interaction also over some time. And the other point, I also agree with June that I think for a lot of young people also the purpose is not totally clear of this individual assessment. And at least in the Netherlands, when a young person has committed a very serious offense and this institute who is doing the NFIP, who's doing the psychiatric also assessments, comes into play, then they become quite scared sometimes, because they think, okay, they're going to make this assessment of me. They say that I'm dangerous and a fool, and it will only get worse because I will be put to prison. But it's of course not the case. It can of course become a prison sentence or treatment, but to treat the young person and to make him better again. But I think sometimes the ideas of young people do not really align with what the goal is of the individual assessment, because they just don't know, and they heard from other people other kinds of stories, and that's not reality in that sense.
I don't know, maybe Gabriella wants to reflect, as she's much into child participation, I know.
Yes, I would say that in Italy, child participation is essential. It's essential for the proceedings. It's essential because, according to the judge, give the responsibility to the social services of justice, the juvenile justice social service, to do the individual assessment. And in this individual assessment, there is a need for the child to participate. He has to participate to the trial, because the judge has to take a decision if the child is imputable, is the age of imputability, but also if it's mature enough to go in the trial, and the degree of responsibility. And then also to identify which is the social relevance of the offense that he committed or she committed, and then which are the measures to be taken, criminal or civil measure to be taken. So I would say that this is essential. And I don't know, of course there are techniques, but I would say, according to the youth that I met, and that is the behavior, the attitude of the professional, that is very important in order to build trust. If the young trust you, so they speak, they feel that they can speak. Otherwise they close themselves. There was this sentence of if they feel mistreated, if they feel not to be understood, I think that this is the end of child participation. But yeah, I don't know, I don't have the key.
Thank you. I just wanted to ask maybe one more question regarding the child participation. How does this reflect in your own countries? Do the lawyers interfere, or let's say interrupt the individual assessment process in any way if they are not well educated for defending young offenders? And do lawyers interrupt in a way with the child participation process if they say, for example, don't speak, don't say anything, and so on? So maybe some reflections on that or comments.
Yeah, I can say that unfortunately, yes, it happens. If, in particular, if they are not well trained, trained to be in the juvenile justice proceeding, which is different, which has a different scope if compared with the ordinary trial. So the scope here is not to punish, is not to, let's say also in the adult proceeding is not the punishment, it's the rehabilitation, and but more in the juvenile proceedings, there is a need to understand the context, the personality, and the offense. But the offense is like something that is comes from these, and I was talking about the circularity of victims and of offenders, because in many cases there are children that are in the same situation, in both situations, victims and offender. But unfortunately, yes, going back to your question, yes, there are lawyers that interfere, and so they say, for instance, not to tell the truth, not to speak, and it's not the right way to do the best interest of the child in this case.
Thank you. Maybe Stephanie or June have any comments on that in your countries?
Yeah, I think the same happens sometimes in the Netherlands as well, that some lawyers might say, especially about the offense and whether the young person is guilty or not, or yeah, saying he has done it, they would advise sometimes to not speak, and yeah, because of the interest of the case. But I think most lawyers who are really trained in juvenile law and are doing lots of these cases, yeah, I think they are quite professional in especially saying to young people that it is in their benefit also to cooperate with the authorities and in the proceedings, and also specifically being open about their personal situation, and that it yeah, could help them in the end. But of course, there are always mixed experiences. And I think it also really depends on the case, and the more serious cases are, and the higher the impact is in the end with regard to sentence, the more criminal justice like the lawyers will be, probably, in trying to prevent long prison sentences from taking place. Although yeah, of course, we in the Netherlands, we don't want to send young people to prison for a long time, but yeah, relatively they can be locked up, of course.
Okay, thank you. And maybe one more question, Neven, and then I will let you speak. Just one question: how and maybe based on which criteria or which elements do you decide in which type of individual assessment will you refer the juvenile to? In Italy and in Netherlands, and maybe in Belgium, if Stephanie knows, I don't know. I understand it depends on the phase of criminal procedure, type of crime, but on which criteria do you decide, okay, so he will go to probation, he will go to, I don't know, forensic assessment or so on, to higher levels and different types of the assessments? I guess you have criteria.
In the Netherlands, it's quite standardized. So in principle, the Child Protection Board does all the individual assessments, but when a young person is already on probation because of earlier cases, or the probation service was somehow involved, then they also can do an individual assessment. And for the more psychiatric and psychological assessments, that is done in serious cases where a closed institution treatment is considered by the public prosecutor. So if he would like to request a judge to place the young person in a closed institution, and I think that because of psychological problems and the type of offense, which is very violent, for example, then they will do the bigger psychological assessment. But it's quite standardized, and also in the procedural law placed, okay, which organization does what, and when do you go to which assessment. And the same instruments are used all the time, I guess. I don't know, June, if you can add something to that. Oh, you're muted still.
I can see you. Sorry. No, I think that's true what you say. Sometimes they do a different research, but only in the respect that it's broader. If they think, wow, this is much more difficult to get a hold of the personality, then they sometimes do an extra psychiatric research, but that depends. And I think that's more if they are in detention than when they are still not in custody. Then it's different, I think.
Okay, and really last question, and for how long does that that type of serious, or let's say comprehensive assessment lasts? For like 30 days, less? How much time do professionals have to conduct comprehensive assessment? Or how many working hours?
How many working hours, right? I think the work in many hours is like 30 hours if a psychiatrist is involved, etc. But most of the time it's of course done in a few weeks. So and sometimes you have a waiting list before you can come, unfortunately, of course, because you want to have, of course, an immediate research and immediate results, but that's not the way it is. I don't know if Stephanie agrees, but I think that's still the case.
Yes, yeah, there are always waiting lists. And I think with the more comprehensive assessment, then the young person is also in a juvenile detention institution. And then I think they also need the time to observe the young person to see how he's behaving in the group and interacting with other young people and staff. And so then they want to see a little bit from the young person. And when they are at home, the assessment is much shorter in time. It's only what I said. I think maybe an interview of 1 to 2 hours, and then writing the report. Yeah.
Well, I don't know if it's 1 to 2 hours, but
no,
because
sure.
it depends.
I hope more.
I know. I think if the NIFP, Stephanie, does it.
Oh, this one is longer. Yeah, but I mean with the Child Protection Board.
Oh no, then it's only.
Yeah.
But if the NIFP does the research when the youngster is still at home, then it will be 18 hours and sometimes even more. But most of the time, it is like a research of 18 hours. That's not 18 hours contact, of course. You know.
I understand. Okay.
The whole process. Yes. Sorry.
Okay. Okay. Thank you very much, Neven. The floor is yours if you want.
I'm sorry, Avril is having her hand raised. No? Okay.
I think it was from before.
Avril, would you like to say something? No?
Well, if you'd like, one or two things. I think that the interference by lawyers, I think that interruption by lawyers perhaps in the writing of reports isn't possible. In the gathering of information and the writing of reports, it's more perhaps earlier in proceedings when they are doing the sort of things that were referred to, like saying, plead not guilty. You've got, but of course you would always go into that and see what the defense would be in that case. He has a defense to this charge, Mr. Smith. Would you like to enlarge on that now? So you can go into that a little bit. When a report comes to court, it breaks down into a report for court when you might be remanding into custody. That's just a remand stage. And I think the lawyers would have quite a lot to say at that stage. And then finally, the final report before a sanction is imposed. Of course, the lawyers would have a great deal to say then. So they have got their positions for input based on the instructions that they receive from their client. But in the writing of reports, they wouldn't. So then another point, participation. I think we can overlook the fact that sometimes the local social workers, whatever they're called in your country, quite often know a family. And they know perhaps another child that's been involved with the courts in the family. So quite often they have a background of information to work on in the first place. And sometimes a child might have been on the fringes of trouble and been brought to their attention but they didn't. So they have spoken to them, they know their name, they know a little bit about them, but nothing happened there, but they do know a little bit about the person. So that form of participation is helpful. And the matching of a particular social worker to a child can happen. I know that officers can be hard pressed, but if they want to match, if they can think that a particular social worker would be better to engage with the child, that they would promote participation, and that's open to them to do that, I think that they would do that. Participation in a court, of course, it's up to the people who lead the court, the bench, to actually promote participation. In fact, we had training in encouraging participation in court. And we must also, when there is a child who doesn't seem to be following proceedings at early stages, we must say, does this child need a mediator? And we do, there is such a body as the mediation body that you can then say, yes, please appoint a mediator to help this child understand what's going on in proceedings, so that that promotes participation of a very vulnerable child. So I think that the thing is, it is, it's multidisciplinary, and I always think it's like an orchestra, and that, you know, there are all these different players in the orchestra, and I often felt that my job was to conduct the orchestra and say, now it is time to hear from this person, now it is time to hear from that person. We haven't heard the nuances about that particular point. Who would be the best person to tell us about the nuances about that particular point? That way, I think you can, a child can see that you're working hard to actually get to a position that is working in their best interests or their best welfare, given that they're in the court in the first place for a reason. You know? I think that's about as much as, otherwise I'll be here all day.
Thank you.
April, I have also the drawing of the orchestra if you want.
Oh, have you? Oh, great.
Yes.
No, I've always felt that it was like conducting an orchestra. Always.
Yeah.
You
I can show it to you.
You just can't make the music, can you? If you haven't got the whole orchestra, the music's going to turn out awful. So
unfortunately, I cannot share the screen with you because I don't know why, but I have
you
here.
can send it to me, Gabriella.
Yeah, okay.
Can I say, since Jolanta was so kind earlier to say thank you, it's been a pleasure for me to work with this particular team on this individual assessment. I would be happy to do it again. So I think you should get another application in there, Jolanta and Ruta, or whatever's coming up next.
Be careful, because sometimes dreams can happen.
Yeah, it happens all the time.
So are we done with the final remarks, Anya, Nevin, right? Yes. So, dear friends, dear colleagues, let me thank you on behalf of EA Child Project team for your attendance. We are looking forward to meet you on June 30th during our final conference on individual assessment. We will have many speakers. Please check our EA Child project website. And I believe that at that day, we will have already our handbook prepared, at least the electronic version, and you can upload it from our project website as well. So thank you very much for your patience. Thank you for being with us. Thank you for the poll results, and see you